It's now my pleasure to introduce Carrie Aaron. She is part of Cumberland Valley Society Human Resource Manager. She has a couple comments, and then she introduced our speakers. Please help me welcome Carrie.
Paul's much taller than me. Good morning, everyone. I do represent Cumberland Valley SHRM. And for those of you who aren't familiar, we are a group of primarily HR professionals. And we meet once a month and have and discuss topics related to the people side of your business. So all of you, we place some flyers for a really exciting meeting that we have next Friday. We will have our speaker, Mike Akins, who is actually the vice president of the legal side of and the legislative side of Cumberland Valley SHRM, or SHRM National, I'm sorry. So he will be here in Hagerstown. It's a great opportunity for you to learn about what's happening at the federal level and how it will impact your organization. So I know all of you are very anxious to hear about this new Maryland legislation. So without further ado, I'd like to introduce Eric Patel and Garrett Wozniak. Eric has practiced law since 1987, concentrating in the representation of private and public sector employers and all aspects of labor and employment law. Prior to joining Coleman & Saucier in 2002, he was a partner with one of the world's largest law firms. Eric's practice includes general advice and counseling, employment matters, as well as the defense of employment discrimination and sexual harassment suits, ADA and FMLA litigation, wrongful discharge suits, wage and hour cases, ERISA litigation, NLRB proceedings, collective bargaining, negotiations, and grievance arbitration. All wonderful HR and employment law acronyms. Garrett Wozniak joined Coleman & Saucier as a law clerk in May of 2012 and became an associate in December of 2013. He has represented clients in mediations, federal and state court, and administrative proceedings. Garrett has also argued before the federal and state appellate courts and represented management and labor negotiations. A significant part of Garrett's practice is counseling and advising clients on employment-related matters. Please join me in welcoming them this morning.
Thanks, Carrie. Thanks, everybody, for being here. I'm going to just speak for a moment. So many of you know me. I'm Eric Patel. I've spoken to Cumberland Valley SHRM for a number of years now. Today, I'm actually going to turn this over primarily to my office expert, Garrett Wozniak, who really has done a yeoman's effort of, to the extent it's possible, trying to master this wacky new law that the General Assembly has kind of jammed down our throats with very little notice. Lots of it don't make sense. You'll look at us, you'll think we're miracle workers, we can interpret it. We really don't know what some of the portions of the law mean either. It's a very poorly written law with no guidance out there, no regulations, but we're going to do our best to tell you what we think is the way to comply with it. So the way this is going to work is Garrett is going to do most of the speaking for about 45 minutes. I'll talk a little bit towards the back end. Then we're going to open it up to questions at 8:30. I'm sure you have lots of questions. We may have some answers. There's also a webinar that we did 2 weeks ago that's up on our law firm website, colemanlaw.com. You can look that up. It's right there on the home page, and we go through a lot of the same stuff we'll talk about today. There's on our website, there's a transcript of questions and answers that we got at that webinar. That's all posted so you can see some of the things we said there. We also have some sample forms we'll talk to you about. No sample policies. We'll tell you why there's no sample policy yet. So that's kind of the overview. So if you could just kind of hold your questions until after Garrett and I are done with the initial lecturing, and then we'll open it up to whatever questions you have. So Garrett, the floor is yours.
All right, so if I'm not talking loud enough, by all means, please just give me a sign and I'll speak louder. So, let's make sure this thing works. All right, so we're here today to talk about the Maryland Healthy Working Families Act. which is a law that we are all learning to love and hate at the same time, right? Because we have to get in compliance with it, or else we will bear the wrath of the DLLR and maybe courts, and there are very onerous penalty provisions in this law, unlike other wage-related and leave-related statutes in Maryland. And Eric will get into that toward the end of the presentation. So the Healthy Working Families Act, the Sick and Safe Leave Law, is the law of the land effective February 11th. There was some talk about delaying enforcement. That became talk about delaying the effective date. That has not materialized. The state Senate passed a bill to delay the effective date of the law to July 11th, mostly out of politics, to say that they were trying to do business as a favor. And now it's this bill to delay the effective date is sitting in the House Economic Matters Committee. There was a hearing on it yesterday. It's everyone's best guess as to what will happen with it. Maybe there will be a delay. Louder?
Yeah.
Okay. Maybe there will be delay. Maybe there will be corrective legislation, but we really just don't know. So if there's any piece of advice to take away from the presentation today, it's get in compliance. Review your existing policies, modify those policies, create new policies as appropriate so that you can comply with the many provisions of this law. You will find in reviewing your policies that you may already provide sufficiently, and you might have to tweak things on the margins, or you may have to do a whole cloth revision and review. And that's some of the things that you'll have to consult with your legal counsel about in order to make sure you're doing it right. DLLR, Department of Labor Licensing and Regulation, will be issuing regulations to provide guidance on how to comply with the Healthy Working Families Act. We don't expect that, based on what DLLR has told us, to come until after the legislative session adjourns in April. So until that time, it's up to folks like Eric and myself, your HR teams, to fill in the gaps and, again, talk to your counsel. So there are a couple definitions to make sure we're aware of in complying with the law. Family member is one, and the reason that's important is the definition of family member under the Maryland Healthy Working Families Act is a little broader than what we're used to under certain laws. So for instance, when we're talking about parent, an employee can take leave under the Sick and Safe Leave Law to care for the parent of the employee's spouse. It's not just the employee's parent. So you have to look at the family member definitions to make sure that your PTO or your universal leave policy, or if it is just a sick and safe leave policy, that the leave can be taken for all of the appropriate eligible family members. Now you might ask, what if somebody comes to you and says, well, I gotta take leave because I have a long lost grandparent? Well, you might wanna provide or request verification so that you can know who the family members are that will be covered and who the employee can take leave for under this new law. One of the things we're suggesting is during the onboarding process, get a list of family members so that you don't discover that long lost relative down the road. Some employers might want to do that, some might not, but that is a way to kind of hedge your bets. Okay, so what can this leave be used for? This is the simplest part of the law. Sick and safe leave can be used for all of the 5 bullet points that we have listed here. So it's illness, medical treatment for the employee or the employee's family member. It is to treat an injury or illness. It is maternity or paternity leave. Or it can be, this is the safe leave component. It's absence necessitated because of, think domestic violence, stalking type situations. And the employee or the employee's family member needs to participate in a judicial proceeding or needs to temporarily relocate for safety reasons, that sort of thing. That is what is covered by the safe component of the sick and safe leave law. Covered employers. Okay, so there was a bit of a misnomer out there that this was a part-time employee law, meaning it only covered part-time employees and full-timers we could rely on our existing policies. That is not the case. Okay, so first off, employers with 15 or more employees must provide paid sick and safe leave. And we'll get into how that manifests itself a little bit later. Employers with 14 or fewer employees must provide at least unpaid sick and safe leave. Now, you can, if you have fewer than 15 employees, provide paid leave, you just don't have to. That's the only difference when it comes to employer size. Employers with fewer than 15 employees still must comply with every other requirement of the law. That's tracking, that's notice, that's prohibitions on what you can and cannot ask, that's how you report the leave, that's how much leave is available, that's when you cannot take action against an employee because they have taken leave. All of that comes into play regardless of employer size. Another question that we've received, and we're attempting to answer, although the law doesn't, is what employees are covered? If I work, and Maryland's a great example of a state in which you can be a Maryland employer, but I have folks who work in Virginia, or I could be a Virginia employer who I have folks work in Maryland. And Pennsylvania comes into play, and Delaware, and West Virginia, et cetera. Well, so what DLLR has said up to this point is that if you have an employee who works the majority of time in Maryland, that employee is going to be covered and therefore is entitled to sick and safe leave under the law. If you have an employee who works primarily in another state and only incidentally works in Maryland, then you do not need to provide paid sick and safe leave to that employee for any of those hours in Maryland, but it has to be an incidental type relationship. So think of it on a sliding scale and use common sense to govern whether that employee is going to be entitled to sick and safe leave and the protections under the Maryland Healthy Working Families Act. There is no definite clear answer at this point. We don't have a hard and fast, if I spend 50% of my time in another state and 50% of my time in Maryland, we don't know that yet, but that is good guidance, and again, common sense will govern here. Another, I'll get this mic figured out eventually, I promise. So covered employees are employees who regularly work 12 hours a week or more. Another undefined term in the statute is regularly. What does it mean to regularly work 12 hours a week? So somebody mentioned tax time. So if an employee we're busy during inventory season or during tax time, or I have a seasonal employee, and during that truncated period of time, that finite period of 3 or 4 months, he's working 12 or more hours a week. Is he covered or is he not covered? What if it's sporadically, meaning 1 week a month he's working more than 12 hours a week, and then other times he's not? Again, that's not clear. So what we're advising clients is to again look at the spectrum. So if I have an employee who once a week or once a month rather, is the only time that employee is working 12 hours a week or more, then that's not going to be regularly works 12 hours a week. And you can exclude that employee from coverage, meaning you do not need to provide that employee with sick and safe leave, whether paid or unpaid. But if this is an employee who for 4 months out of the year is working more than 12 hours a week, then probably during that 4-month time period, you're going to want to provide sick and safe leave to that employee. And I know it's not clear, and it's a tracking headache. So your HR folks and your benefit folks are gonna come to you and want a bottle of vodka, because this is gonna be a big pain in the you-know-what. But it is what it is, and we just have to deal with it. It's unfortunate, but as we work to comply, we're just gonna have to be patient and go back and forth and do our due diligence with our HR teams in order to properly track what employees are entitled to under the law. Okay, so who is not covered? By the way, so what I'm trying to not do is just read from the slides. So as Eric mentioned, this presentation is available on our website. So if you want the bare bones, what you're going to see on the slide is directly from the statute. What we're trying to do here is fill in the gaps and answer some of these questions that have been raised but have not yet been answered. So while a lot of employees are covered, and the estimates are 700,000 employees will be covered in the state of Maryland by this law, there are a lot of exemptions that are built into the law. And some of those exemptions make sense. Some of those exemptions were driven by powerful industry lobbyists. And so you have to sort through that. And so what we see on this slide is some of the individuals who are not covered. Individuals who work fewer than 12 hours a week, as I mentioned, are not covered. There is an exemption for individuals in the construction industry who are covered by a CBA, There are exemptions for certain individuals in the health and human service industries, but there are a number of criteria that have to be satisfied for those employees to be exempted from the act. So if you're in the health and human services industry and you think that your employees might be excluded from coverage, look at all the criteria. Just don't stop at bullet point 1 and think that you have an out. You have to check all of the boxes, or else you could be in for a world of trouble. Independent contractors are not covered, and the test that the DLLR is going to follow in determining whether an independent contractor is covered or not covered is the same test that will be as used in the unemployment insurance context. And again, if you have questions in that realm, contact your counsel. Individuals who are under the age of 18 before January 1st are not covered. So for 2018, an individual your employee who was not 18 on January 1 of 18 is not covered. In 19, that individual would be covered. In 2019, an employee who was under 18 as of January 1 of 19 will not be covered until that individual, you follow with me? So there's that exclusion. There's exclusions for the agricultural sector. There's exclusions for temporary service agencies. And this is an interesting exclusion that Eric and I were just discussing the other day, is the way the law is written, and this is an example of how the law is poorly written and probably not what the legislature intended, but it's how we read the law, is if you have an individual who's employed by a temporary service agency, and the agency does not have day-to-day control over the assignments of that individual, then that employee is not covered by the act, either with respect to the temporary services agency or with respect to the third-party client. I don't think that's what they intended, but it's certainly how it reads. So there's that is something to keep in mind as well. If you have a unionized workforce and you had a collective bargaining agreement that was entered into before June 1st of 2017, so this is a very important date, June 1st of 2017, before that date, then you do not have to modify that collective bargaining agreement. You don't have to go to the table regarding that agreement until it expires, and whether that's in 2018, 2019, 2020, et cetera. But if you have an agreement that was entered into after June 1st of 2017, even if it doesn't expire until 2020, you've got to modify your policies. You've got to comply with the Healthy Working Families Act, regardless of what the contract says. You could have just left negotiations. You got to talk again. This is where these situations are victims of the procedural process that led to this law going into effect with the veto and the override of the veto. The law wasn't amended to modify the dates. So that's unfortunate. We're dealing with it, and if that's your situation, that's something that you will have to approach as well. A lot of the questions that we're getting up to this point have to do with existing leave policies. So the law has a carve-out that says employers do not need to modify existing leave policies so long as those existing leave policies are at least as generous as what the Healthy Working Families Act requires. So what that means is the leave accrues at least a rate of 1 hour for every 30-hour work. It can be used for all the reasons set forth in the Healthy Working Families Act. You are not asking questions that are prohibited by the Healthy Working Families Act. You are not requiring notice that is more conservative than what the Act requires or permits, rather. And again, I'll dig into all of that. So if you have an existing leave policy that provides, for example, 40 hours of leave over the year, it might be that your best solution is to modify that policy on the margins so that you can comply with the Healthy Working Families Act instead of creating a new policy out of whole cloth, or tweaking a sick leave policy instead of creating a new policy out of whole cloth. And so when we're talking about existing leave policies, we're talking about vacation, sick, short-term disability benefits, floating holidays, parental leave, and then the last bullet is other paid leave. And again, the key caveat there is those policies have to be at least as generous as what the sick and safe leave law requires. I'll back up real quick. There is another out if you don't have to modify a policy if you're not going to reduce an employee's pay because of an absence necessitated by sick and safe leave. I've not encountered an employer that's going to do this, but that is an out too. So if you just want to say you have sick and safe leave for that sort of reason, we're not going to deduct your pay for it without limit, then you're complying with the law. But that can get very costly very fast. So what do you do if you have an existing PTO policy, and one of the things in the law is that you have to report each pay period in writing or through some sort of HRIS portal the number of sick and safe leave hours that an employee has available to use? Well, one thing to do is if you're going to, let's say you have an 80-hour PTO policy over the course of the year, and you're going to treat it all as the most restrictive components of the law require, then what you're going to do, potentially, is just report PTO. You have 60 hours of PTO left as of July 1 of 2018. But if you, because the law permits you to cap the amount of sick and safe leave at 40 hours a year, you can't earn 40 hours in a year. You might want to segment out your PTO so that when you're reporting to your employees, they know that they have 40 hours of sick and safe leave under your PTO policy, that we're going to follow the stricter requirements of the Healthy Working Families Act to the letter. And then for the other 40 hours, we can be more onerous. If you're going to use these PTO hours for vacation, for example, then we want 2 weeks notice. Or we're going to ask you for proof of where you're going, things like that, things that we cannot otherwise require of our employees under the sick and safe leave provisions. Now that might make it more complicated for you. I mean, you say that's not worth the effort, but in which case, if you want to treat all hours of leave under a PTO policy the same and still satisfy the requirements of the law, then you're going to have to be more generous to your employees. The key is to track the leave, figure out how generous you want to be, and then modify your tracking and reporting requirements and obligations to comply. So the example we have on the slide here is if an employee relies upon an existing PTO policy and then an employee quits with a PTO balance. So, okay, I guess I'm jumping ahead. But so one of the requirements of the law is if an employee separates, regardless of reason, then is rehired within 37 weeks, you have to reinstate the full amount of sick and safe leave that the employee had earned at the time of termination. So if we're using a PTO policy, and again, I'll use my 80-hour example, but I only want 40 hours of that to be sick and safe leave, then all you would need to do is reinstate the 40 hours, because that's your 40 hours of sick and safe leave. But if you're treating that full 80 hours as sick and safe leave, then after that within that 37 weeks, you would need to reinstate the full amount of leave. And so again, it can get tricky depending on how you're treating your PTO policies in order to comply with this reinstatement provision that the law contains. Okay, so let's get into some of the minutiae. Accrual rates and permissible caps. So at a minimum, the leave must accrue at a rate of 1 hour of leave for every 30 hours worked. That's not nearly as generous as a lot of policies that we're seeing out there. The leave begins accruing for existing employees as of February 11th. Okay? For employees hired after February 11th, it starts accruing on the date of hire. But you do not need to let employees use the leave until the 107th day of employment. That's the most restrictive you can be. So for instance, if you have a 90-day probationary period, that would be compliant with the law, meaning on day 91 you can use your leave, That's within the 107 days that the law permits. You are not required to allow an employee to earn more than 40 hours of sick and safe leave in a year. That's 5 days. You don't have to permit employees to use more than 64 if they've accrued up to that amount or you front-loaded up to that amount in the course of a year. And you don't have to permit employees to accrue a total of 64 at any time year over year. What you do have to do is if employees are accruing sick and safe leave under the law, then you have to permit employees to roll over, carry over up to 40 hours of leave from year to year. So there's an example. I'm gonna try and use this example, and I hope it's not too complicated, but this question has been coming up more and more frequently, so I think it might be helpful. And if I see your eyes glazing over, I'll try again, and if that doesn't work, ask me at the end and I'll try yet again, or Eric will do a better job. Okay, so if you have an employee, you're doing an accrual system. So you're gonna permit this employee to accrue 40 hours of sick and safe leave in 2018, okay? That employee has a really good 2018, doesn't get sick, none of his family members get sick, so he doesn't use any of those 40 hours, okay? He rolls over 40 into 2019, has still not used any leave, so he has 40 in the bank. Everybody with me? Okay. So, because we can cap accrual at 64 hours, that employee can only accrue 24 hours in 2019, okay? He still doesn't get sick, none of his family members get sick, there's no safe leave situation. Once this employee gets to 64 hours, he's capped under the accrual system. So therefore, he stops accruing in 19, even though he hasn't earned 40 hours in 2019. But then he gets sick and uses 24 hours of leave in 2019. So he's down to 40 hours in his bank. You still with me? Okay. So he's down to 40 hours in his bank. He had only earned 24 hours in 2019. He had 16 hours left that he could earn in 2019, so he's earning again until he gets back up to 64. Does that make sense? Okay, so whatever numbers you use, if you're gonna rely on these caps, these are permissible caps under the law, but you don't have to follow them. I mean, you don't have to be as restrictive as them. But if you do, remember that, because the numbers change depending on how much leave is used or is not used. We got through that a little bit better than I expected. Thank you. Okay, I mentioned the 106 calendar day requirement. Again, you're accruing on day 1, you can't use until day 107. That's the most restrictive you can be. Year. If you find it better for your operation to operate on a fiscal year instead of a calendar year, you can do that. If you find it better to work on a calendar year instead of a rolling 12-month year, you can do that. If you want to use a rolling 12-month year, you can do that. We think it makes logistical sense to have a defined 12-month period because you can look at all of your employees as of January 1st or as of October 1st or as of July 1st, whatever your year is, instead of a rolling 12-month period. But you get to pick that. What the law says that what year means for purposes of the Healthy Working Families Act is any 12-month period that works for you unless the context dictates otherwise. So find out what works for you and implement your policy based on that definition of year. So I talked a little bit about carryover already. Another question that we've gotten from time to time is prorating. So I'm gonna give 40 hours of leave. But I don't hire the employee until July 1. Do I have to give 40 hours, even though this is only gonna be a 6-month employee for this year? And yet again, this is an example of an area in which the law does not answer the question. So what we are advising folks is to prorate. And unless and until we're told otherwise, prorating, it's common sense and it works with the spirit of the Healthy Working Families Act. So if you have an employee that's hired 6 months into the year, meaning on July 1, then you would have a 20-hour leave bank, just for purposes of this law, that the employee could not use until day 107. and then they could use that 20 hours thereafter. So prorating might be something you want to consider. We talked about the carryover. So you have to permit carryover of leave if you use an accrual system. If you front load the system at the beginning of the year, and again, whatever year you pick, you do not have to permit carryover. So this is a benefit to front loading. I'm going to provide the 40 hours or the 60 hours or the 80 hours of leave every year on January 1, but on December 31, it's use it or lose it. And then we start anew. So there's a benefit to that if that's a route you want to go. Part of what we're seeing and how employers are responding to this option is it really depends on what our existing policies say. If I'm already front loading, certainly it's going to make sense to stick with it. If I have a generous accrual system, I might not want to be that generous and front load 80 plus hours. You know, employers are very generous with their leave policies these days, and I'm not going to front load 80 plus hours on January 1st. Even if you front load, you're on the hook for tracking. This is a very important requirement in the law. Every pay period, you have to let your employees know the number of hours they have available for sick and safe leave purposes to use. And the reason that becomes important, as Eric will get into a little bit later, is sick and safe leave is protected leave. And you really can't take, it's almost immunity leave. You can't take action against an employee for using sick and safe leave, even if they screw up on their notice provisions, because there's this provision in the law that says you can't. I'm stepping on your topics. I apologize for that. You can't count a sick and safe leave absence as part of an absence control policy. So I'm taking sick and safe leave. I don't provide notice. You might be able to deny that leave, but I can't count it as a strike one, even if I don't provide proper notice. And it is what it is. I wish I had a better answer for you, but you have to, chew and swallow. All right. All right, so termination. All right, you do not have to pay out sick and safe leave upon termination. But as we all know, if you're not going to pay out sick leave upon termination, you got to have a policy. It's got to be written, and your employer's got to be made aware that you're not going to pay out sick leave upon termination. That's not new news for us. I mentioned the reinstatement amount. Unless you do pay out the sick and safe leave upon termination, you have to reinstate it if the employee is rehired within 37 weeks. The reinstatement provision, again, applies regardless of the reason for termination. You could have had somebody who was violent at work, was stealing from you. There is no out for terminations with cause. Not that you would rehire this person anyway, unless you're a saint, but no, there's no out. Okay. There is another exception, which again, we're finding that employers find to be more difficult than it's worth pursuing, but it's there, so if you want to pursue it, you should know about it. And what this provision says is, you don't have to permit employees to accrue. Even so, I have an employee who regularly works 12 hours a week or more, so would otherwise be eligible for sick and safe leave. But you don't have to permit this employee to accrue sick and safe leave during certain pay periods. So the first is the 2-week pay period if the employee doesn't work 24 hours, at least 24 hours in that 2-week pay period, okay? You don't have to accrue during that period. If you want to monitor employee hours to that degree, then you don't have to give that employee leave accrual during that period. Or during a 1-week pay period if the employee worked fewer than 24 hours in the current and immediately preceding pay period. And then the pay period in which an employee is paid twice per month, regardless of the number of weeks in the pay period, again, if the employee works fewer than 26 hours. I know. Follow the numbers. Now you're understanding why I said employers seem to just be looking at these outs that the law provides and saying, yeah, next. It's easier. It makes you think. Maybe the legislators are thinking, we're just going to make this so difficult. Employers are just going to give 40, 60, 80 hours to leave and be done with it. Okay, advancing leave. advancing leave is really no different, I don't think, than how we typically operate already. So you can advance sick and safe leave, and again, I'm calling it sick and safe leave. Your policies might call it PTO, your policies might call it universal leave. But you may advance the sick and safe leave before it's accrued. Okay. If you do that, and you want to recover it, if the employee leaves your employment before accruing enough leave to get out of a negative balance, you have to have a signed writing authorizing you to deduct that from the employee's wages. That's not going to be new news to most of you, but you should get that, have it in your policy, get that signature as part of your onboarding process or for your existing employees. Get it now so that if you are going to permit advancement of leave, that you have your ability to recover down the road. You have to mutually agree in writing. There can be no pressure to do that, of course, and if the employee says, no, I'm not going to sign it, then you know what, just don't advance that employee any leave. Okay, I've alluded to tracking. Tracking is such a big component of this law. First, sick and safe leave. So let me back up. If we're gonna use a PTO policy to comply with the Healthy Working Families Act, or if we're gonna have just a sick and safe leave policy, the most that you can require an employee to use is 4-hour increments. You can't require a full day. It can be the smallest increment that your HR system permits, but the most you can do is 4 hours. That's it. Whether you call it PTO, whether you call it sick and safe, okay? 4 hours is the max. So that's why it's important, if we're just gonna modify an existing PTO policy to comply, that we make sure we're not requiring PTO to be taken in full day increments, because that PTO policy would not be compliant with the Healthy Working Families Act. So you have to look not just at the amount of leave that we're providing, but all these other around the edges issues about leave usage, notice, tracking, etc., to make sure that the holistic policy complies, and therefore we can fit that square peg into that round hole. Yeah. So if you're going, just another reminder, if you're going to go with the PTO policy and you're going to want to treat some of those hours more liberally or more conservatively than others, you're going to want to segment those out each pay period so that an employee knows, I have an 80-hour PTO bank, I've got 40 for sick and safe, I've got 40 for PTO, and for that non-sick and safe reasons, I can ask more questions, I can require more notice. And I believe I have an example here momentarily that I will illustrate for you. Abuse. So this is a law that is going to be abused. And the reason it's going to be abused is employers, there's no teeth that employers can use to hold employees accountable until such time as an employee misses or uses sick and safe leave for more than 2 consecutive scheduled shifts. Okay, so before I back into this, you can only require documentation or verification of the need to use sick and safe leave if an employee has used the leave for more than 2 consecutive shifts. That doesn't mean full shifts. That means I use 4 hours of leave on Monday, I use 4 hours of leave on Tuesday, and I use 2 hours of leave on Wednesday. That's more than 2 consecutive scheduled shifts in my book. Until DLR tells us otherwise, that's what we're going with. Okay, that's the only time you can ask for verification of leave. So if I miss work for sick and safe leave reasons on Monday, I work Tuesday. I use sick and safe leave on Wednesday. I work Thursday. I use sick and safe leave on Friday. You can't ask me for written documentation, or otherwise you're violating the law. Right. So you said, Garrett, that's never going to happen because who gets sick? Well, I tell you what, the good games in March Madness are going to be on Monday, Wednesday, and Friday, and you're going to see who's showing up for work. Okay. And as long as UVA loses, we can all be happy. And I only say that because Eric is a UVA. Okay. So what do we do about abuse or improper use? So what the law says is that we can have policies that prohibit improper use, or policies that prohibit a pattern of abuse. And what that means is everybody's best guess. It's not defined. We don't know. So what we've tried to do here is come up with some examples of how we think abuse or a pattern of abuse will manifest itself. So consistently not providing notice, or taking the leave on a Monday or a Friday, or the day before or after a holiday. Or use the March Madness example. Those are days that we are all aware that employees like to be liberal with when they get a cold and the sniffles. Okay, so be mindful of that. So can I deny somebody leave if I think there's a pattern of abuse or improper use? Maybe. And I wish I had a better answer for you. Because the only reason, according to the law, that you can deny leave is if an employee does not provide proper notice, and this is a big and, it will cause a disruption to the employer. Okay, and disruption is not going to be an inconvenience. It's, I gotta find somebody. That's not going to be enough. Now, I think your hospitals, your daycares, your folks where there's a head count ratio required by law are going to have an easier job, an easier time showing disruption than a retail operation, for example. So keep that in mind. So we are still trying to figure out what exactly it means, or what good is it to have a policy prohibiting a improper use or a pattern of abuse if you can't deny the leave, you can't count the absence as part of an absence control policy. So what do you do? I gotta say, it's to be determined, and I wish I had better answers for you on that front, but I think you should proceed with caution until we know more, because you don't want to step in it. All right, employee notice obligations. So I've talked again about treating PTO differently than sick and safe leave and what you can and cannot do. And here's one of the ways in which this manifests itself. If sick and safe leave is foreseeable, the most you can require in terms of advance notice is 7 days, okay? No more than 7 days. So if I have a PTO policy that I'm using to satisfy sick and safe leave, one option would be, for all of it, it's foreseeable, 7 days or less. Well, let's say I have an 80-hour PTO policy, and I'm going to cap the sick and safe leave component of that at 40 hours. Well, for those 40 hours, 7 days is the most I can require. But if you're going to use the other 40 for vacation, I can require 2 weeks notice. But if you're going to go that route, that's when the segmenting out of the leave and the reporting at every pay period comes into play. So this is going to depend on your workforce and your logistical capabilities and what you determine to be feasible. Is it worth the effort to track this type of leave separately so that I can require more advance notice? Or you know what, Garrett, I really don't care. 7 days is the most I'm going to do. It makes it easier when it comes to tracking. Does that make sense? Okay. If the leave is not foreseeable, and that happens, we get that, you can require notice as soon as practical. And you can also require employees to generally comply with your notice provisions. But what you can't do is, you can't deny the leave, you can't interfere with the ability of the employee to use earned sick and safe leave. So I have banked leave, I get it overnight, I got my head over the toilet, I can't make it to, I can't text, I can't call, I can't email, I can't Instagram, whatever. Okay. You still have to permit that employee to use the sick and safe leave, okay? Even if you don't get notice until 2 hours after the shift. Man, Garrett was supposed to be here at 7:30 and it's 9:30. Oh wow, if the employee has banked leave, they get to use the banked leave if it's for a sick and safe leave reason, period. Okay. The key is have your notice provisions, apply your notice provisions, consistently enforce them, but when it comes to sick and safe leave, you gotta pause and just do a little due diligence before you take any action, even for employees who don't provide proper notice and leave you in a lurch. When you get to the point in which you can ask more questions, okay, what we recommend So I go to Eric and say, Eric, I'm sick today. I need to use sick and safe leave reasons. Okay, Eric's gonna say Garrett's out because he's gotta go to the doctor because he got a cold. That's all Eric as my supervisor should know about my leave status. If we're gonna get to the point where we can request verification and get more documentation, we recommend that your HR team, your benefits team get involved. That's not we don't want confidential medical information going to frontline supervisors. That's when your HR folks should get involved. So supervisors should know the reason for the leave in terms of topical, categorical reasons, but not the underlying condition, because then you're getting into ADA, maybe FMLA land, and you don't want to do that. That just opens a whole can of worms that is better left to your HR and benefits teams. For family legal relationships, again, I suggest at the beginning of an onboarding process, get that list so you have just something to refer back to. If you want a broader family list, if you want to include domestic partners or things like that, you can do that. The family member definition that we looked at before is just what is required by the law. So that's that. This was the example I was referring to earlier. So if I'm going to offer 80 hours of PTO and I'm going to front load it, okay, January 1 of every year, you get 80 hours of PTO. For the non-sick and safe leave reasons, I'm going to require 10 calendar days notice. So if you're going to go to Ocean City, or if you're going to go to Garrett County, or wherever you go for vacation, then 10 days notice. But for the sick and safe leave, just 7 days. Again, if you want to go that route, you can treat the leave differently. If you're going to use the entire PTO as sick and safe leave, that is fine, but you must recognize that you're going to have to treat that entire bucket, that entire 80 hours in this example, as sick and safe leave. Okay, so tracking. Each time wages are paid to an employee, you must provide a written statement of the amount of sick and safe leave the employee has available. So this could be on a pay stub. This could be an insert in a paycheck. This could be on, if you have a website where the employee can go in and log on. Those are all ways in which this can be satisfied. Excuse me. What we recommend if you're going to have a more generous policy, you're going to treat the leave differently, again, is to segment out the leave. It might also be helpful if your systems permit this to not just report leave used, but leave available so that you have that proper tracking and you can reinvent the history and the timeline should your back be against the wall and you have to justify what occurred. Again, as lawyers, we always think in worst case scenarios, or often think in worst case scenarios, I should say, and we like to be able to connect the dots. And so this goes to helping connect the dots. More examples here just to kind of illustrate what I've been talking about when I'm referring to these bigger or larger PTO buckets. In the first example, if I offer 80 hours of PTO, again, providing it to employees on January 1st. So for the pay period ending February 28th, I would report, so you've been credited 80 hours of PTO, your sick and safe leave used is 12 hours, your non-sick and safe leave used is 8 hours, therefore you have 60 hours of PTO, 28 of which I'm gonna follow the strict requirements of the Healthy Working Families Act. The others, I'm not, and therefore I can require more notice, I can ask more questions, etc. Example 2 on the accrual system, if I accrue at a rate of 1 hour for every 30 hours worked, which again is the bare minimum permitted under the law. So after an employee has worked 900 hours and is eligible to use the leave, so he's passed or she has passed 106 days of employment, I would report 30 hours accrued. Okay, this employee has used 12 hours of leave and therefore has 18 available. It can be simple. It can get more complicated depending on how you're structuring your system, and it really is going to depend on what your existing policies say and how you want to modify them. All right, and then verification. So I've mentioned this already. This is the key. So you can only require verification again, more than 2 consecutive scheduled shifts. And the way that we have interpreted the statute thus far, and again, the statute doesn't say explicitly, DLLR has not answered this explicitly. This is our interpretation based on what the law says. It's more than 2 consecutive scheduled shifts. Is therefore, it could be 4 hours on Monday, 4 hours on Tuesday, 4 hours on Wednesday. You just have to get 2 consecutive shifts plus 1. And that's in terms of hours. It doesn't say full shifts. The other way you can require verification is if the employee uses the leave in the 2-week period following the 106 days of employment. So, as I mentioned, you don't have to permit employees to use sick and safe leave during their first 106 days of employment. So if the employee uses leave between days 107 and 120 inclusive, then you can require verification of leave during that period if, and it's a big if, at the time of hiring, you got signed authorization saying you could require verification during that 2-week period. I mean, this is a hyper-technical detail that it's there for a reason, and I guess they don't want somebody just to work for 106 days and then use leave and then quit. But if you're gonna require verification during this time period, you have to get approval in writing signed by the employee at the time of hire. If the employee does not provide verification when you've properly requested it, all that permits you to do is to deny a subsequent leave request if that leave request is for the same reason for which the employee did not provide verification. Okay, so I missed 3 days of work for the flu. You request verification from me, I don't provide it. I have a stroke. I just came up with that as a bad example. You can't request verification of that. Okay, I mean, you can't deny, I misspoke. You cannot deny my leave request for that reason because it's a different reason. Or what if it's the cold and then the flu? That's different reasons. The flu's making its way through my house. First time it's my son, second time it's my daughter. Different reasons, same reasons? I don't know. So these are unanswered questions, but the way the law reads, you can't deny the leave, even if I didn't provide notice when you properly requested it. The advice there would be to contact your lawyer. Seriously. What can I do? I mean, this guy is clearly playing games with me.
Move to a different state.
Move to a different state. There you go. There you go. All right, my last slide before I turn it over to Eric and make him talk really, really, really fast is shift trading and coverage. Okay. Employers may not require employees seeking to use sick and safe leave to find a replacement. Okay? But you can voluntarily, with the employer and the employee can voluntarily agree to trade shifts. But again, it can't be required. If you're going to do that, you want to have that documented that it's a mutually agreeable relationship. There are specific requirements there. I think they had in mind really the restaurant industry in particular, and there are specific regulations governing the restaurant industry here, and I think Eric's going to cover some of that. So just be aware of the shift trading and coverage provisions of the law. They are technical, and you want to look at those if you're going to want to go down that road and have that conversation with your employees. So with that, I know I was talking fast, or I think I was talking fast, but there's a lot of material here. It's dense. We hope to answer a lot of your questions, and we're going to leave time for that. And until then, I'm going to turn it over to Eric.
Thanks, Garrett. If any of your employees try to pull the March Madness garbage excuse, let the record reflect that I was up till 11 o'clock watching my #1 ranked Virginia Cavaliers beat Miami last night, then texting my college roommates for half an hour afterwards, and still got to Hagerstown by 7:29 this morning. So it can be done. Don't buy that excuse.
What were you doing Saturday night?
Moving on to the Maryland Flexible Leave. For those of you who don't know, my Wahoos lost to the horrible Hokies on Saturday night. Bad day for a Virginia guy. Maryland Flexible Leave Act still is the law. Applies to private sector employers with 15 or more employees. It does not apply to those of you in the public sector. Why, you may ask? I think the answer is because O'Malley was governor when this was passed, and he had different standards. But anyway, that's digressing into a different topic. The thing with the Maryland Flexible Leave Act is it's a law that requires that you allow employees to use any paid leave they have available to them for the same or for the illness of a family member, and under the same terms and conditions they could use it for themselves. So you may think, well, why do we need to have two laws like this? There really isn't much reason for two laws like this now, but where it's going to kick in is for somebody who has either burned up all of their ESS under the Maryland Healthy Working Families Act, or has not yet accrued, or has not yet got to 106 days. So it's like a bookend, as we describe it. For those people who fall outside of ESS leave, they can still take leave in accordance with the Maryland Flexible Leave Act. Garrett talked briefly about the restaurant industry exception. I'm not going to bog down in this. It's a rather specialized exception. It applies only when more than half of your revenue is derived from food sales. So if you're mostly a bar and not making a lot of money off your food sales, not going to kick in. But for restaurants, there is this shift swapping availability to you. We can talk about that during the Q&A because it's rather specialized. Let's get to the notice posting, because I think that's the more substantive topic that people are concerned about. You do have to have a notice to your employees of what their rights are and responsibilities are under the Maryland Healthy Working Families Act. There is now a sample notice available from the Department of Labor Licensing and Regulation. We have it up on our website as well. We don't think the sample notice that's out there is quite as helpful as the one we have developed. Garrett has put together a very good sample notice that we think is a bit more user-friendly than the one put together by the state. The state one more or less just parrots the language of the law back at you. There's nothing that says you have to use the one the state has issued. You can use the one we did, or you can create your own. And a good example of why you may want to vary from the state model is the state model talks about accruing leave at a rate of 1 hour for every 30 worked. Well, if you happen to front load the leave, then employees might be confused. They got this notice talking about accruing it at 1 hour for every 30 worked, but your policy is front loading all 40 hours immediately, so there's some inconsistency. So I had one client, going back and forth with me by email yesterday, wondering why the state didn't address the front loading in their sample, and I think the answer is the state, like everybody else, is operating on a very quick ad hoc basis right now. They may tweak the notice at a later date. But the key thing for you to understand is you must have this notice either in a handbook, posted on the internet, maybe up on a bulletin board, some means of communicating to your employees the information that's set forth in this slide. Record keeping. We've been getting a lot of questions from people saying, look, if I just let my employees use their PTO for all the reasons why they're required by the Maryland Healthy Working Families Act, do I have to go through all this pain in the derriere record keeping stuff? Here's what the law says, folks. The law says you must keep records of the ESS accrued and used by each employee, and you got to do it for 3 years. As you're going to hear me talk about in a second when I get to enforcement, the way somebody would bring a claim under this law is they would contact the Department of Labor Licensing and Regulation, an investigator would come in, and they would ask to see the records, probably not just for the one person complaining, but probably for your entire workforce, to ensure that you are in fact doing what the law says you're supposed to do. The failure to maintain those records, as we say on the very bottom bullet there, creates a rebuttable presumption that you violated the law. When you hear me talk about penalties in a minute, you're going to realize that's not a good place to be. It means you're on the 1 yard line with time running out. And it's up to you to prove that you were fully compliant with the law. So keep the records of ESS usage. As Garrett said, make sure every pay period they're getting that notice of what they have available, and maintain the records. Prohibitions, Garrett's already touched on this. to some extent. I know there's a lot of questions on this, and we'll be happy to entertain more during the Q&A period. But essentially, you can't do anything bad to people because they've used or tried to use ESS leave. If you do anything to interfere with that God-given 40-hour right that they have, you can get yourself in a heap of trouble with the Department of Labor Licensing and Regulation. And if the State House should change control this fall, it'll probably be even a bigger heap of trouble than you would be in right now, because it's something which, as I said, somebody has to go to DLLR first to complain, and once DLLR sends an investigator out to your workforce, they're probably going to do a fairly broad investigation, and it can be a big problem for you. So this bottom bullet is critical, folks. You cannot have a policy that treats any ESS absences as an occurrence. And if I've had this question over and over from clients, and the answer doesn't change. You can't treat it. If it's within their accrued ESS leave, they get immunity. Enforcement. So, as I said, somebody who thinks they've been denied their rights has to go to the Department of Labor Licensing and Regulation to bring that complaint. You may ask, well, when do they have to do that? How long do they have? And you know what the answer is? Good question. General Assembly should have thought about that when they wrote this law. They had a number of years to do it. Well, nobody ever really thought about putting in how long somebody has to go. We can hope that when regulations issue, or maybe if we're really lucky, in corrected legislation during this session, they will go back and amend the law to say that there's some statute of limitations out there within which somebody has to go bring a complaint. But as it stands today, there is no limit. Good news is the law just took effect on Sunday, so it's kind of academic at the moment. The state's got a 90-day period within which to investigate. If they do not get to a point where you as the employer own up to your mistakes and correct things, and they determine there's been a violation, they can then issue an order against you that you have violated the law. The penalties are pretty harsh. It's $1,000 per employee per violation. And that could be for something as mundane as a record-keeping violation, folks. So if you think about that, just because you decided it was too much trouble to keep track of all the ESS leave, if you get nailed in an investigation, you'd be looking at $1,000 per employee per violation. That would add up very quickly. I had a small nonprofit on the phone with me yesterday, and I could just hear the blood drain from their faces. I explained that to them during the phone call, because their attitude up until the phone call yesterday was, you know, this is silly, we're kind of a do-good company, nobody will come after us because we're a nonprofit, we help people out. There's nothing in the law that gets you off the hook just because you're good people. If they find a violation, you've got 30 days to comply. If you don't comply, they can issue an order. You can challenge that order in court. You can actually go to circuit court and try to sue, but at the same time, an employee can go out and bring a private lawsuit against you within 3 years of the date that order issues. And the damages there were really a gift to the plaintiff's bar in Maryland. I think we've all come to the conclusion this is the most generous statute that Maryland has in terms of remedies available to private plaintiffs. They get triple the damages, plus they can get punitive damages, plus they can get their attorney's fees. There's no other employment law in Maryland that provides for both treble damages and punitive damages. So that's a very, very lucrative incentive for the plaintiff's lawyers to jump in and try to sue if you violate the statute. Very quickly, there's still other laws out there. Don't forget, we talked about the Family Medical Leave Act, Workers' Compensation, the Maryland Flexible Leave Act. None of those have gone away. For those of you who have the joy of operating in Montgomery or Prince George's County, you may already be dealing with this. Montgomery County law it remains in effect. The Prince George's County law, there's some ambiguity as to whether it is preempted by the Maryland Healthy Working Families Act. There's been conflicting advice back and forth as to whether it is or is not. Those of you who are federal contractors may also be dealing with an executive order which took effect January of last year, 2017, that requires that you give 8 days of paid sick leave. That still remains the law as well, and you would comply with that concurrently with your obligations under Maryland law. Next steps, if you haven't done it yet, start moving real fast when you get out of here today to review your policies, make sure they're compliant with the new law. Talk to us or whoever your counsel may be if you need some help doing that. But the clock is running, folks. The meter, the accrual meter has been running since 12:01 a.m. on Sunday morning, and folks who are eligible for the leave are already accruing, and your record-keeping obligation, in theory, begins the very next pay period that you have. That notice should be up in your workplace or in your handbook. So there is still this remote chance that the General Assembly will take action to delay the effective date till July 1, but I think, and Garrett will probably tell you even more than me, that's highly unlikely that's going to happen. It's almost certain this is it, we're stuck with it, and unless you choose to cross the border and go to a more business-friendly state, this is what it's going to be for the foreseeable future. So we are now wide open to questions. This guy really knows the law, but I know a little bit about it, so fire away.
Yeah, I've got a microphone here.
Two quick questions. Can you segregate between full-time and part-time employees? Like, can I have the sick leave policy for my part-timers and then a PTO policy that complies with the sick leave for full-timers?
Yes.
Okay.
Yeah, if you want a policy for your full-timers that is a PTO universal X number of hours as long as it's compliant, and then you want to do an accrual system, for instance, for your part-timers, you absolutely can do that. Just when you segment out, there's a legitimate business reason for it, and you're going to comply with the law.
Okay, and then the only other question I had is, you kept saying 4 hours, so if employee A is out sick on Tuesday, I can only charge them 4 hours against their sick leave?
Good question.
Garrett, can you also use the microphone? 'Cause we're
Yes. The most you can require is 4-hour increments. If the employee needs the whole day, they can take the whole day. You can just, I have a 1-hour doctor's appointment. Okay, well, you got to take 4 hours. You can require that. But if I'm going to take the full day, then of course the employee has the right to do that if they have the bank leave.
Okay, thank you.
I'm interested in a definition of human service industries, and also if you, yeah. And we have a lot of as-need employees. If you had a document that signed that they realized that they were as-need and that we would only call them if we needed them, does that help?
So what the statute says regarding this law, I've read this thing probably 4 or 5 dozen times, and I still need to go back to it. For the health and human service industry, one, it's not defined. So if you want to know if you're in the health and human services industry, what I've been doing for clients is going to the Maryland Code and looking at the various provisions and seeing if we fit in. So your hospitals, your daycare providers, things like that. I don't think so. I don't think so.
They're a human service.
So, but what we're looking at is what is the definition. So the best we have at this point is to go into the statute and see if it's an industry and occupation that falls within that definition within the statute or within Maryland regulations. And then even then, it has to be an on-call employee who is on an as-needed basis, who is free to accept or reject the shift and is not guaranteed work. Again, so this is when I was talking earlier about needing to check all of the boxes. You can't just stop it at box 1. I had a client who said, well, I'm in the health or human services industry, I'm off the hook. Well, not so fast. So I know that's not a great answer, but it's the best we have at this point.
You had an on-call question too, right, about?
Well, we only provide employment if we have people coming. It's a hospitality situation. If we don't have any group that weekend, we don't pay them.
I don't, my sense is that hospitality is not what is meant by health and human services industry.
One of the slides indicated that leave could be denied if a pattern existed, a pattern of abuse. What's a pattern?
leave can only be denied if an employee does not provide proper notice and the absence will cause a disruption to the employer. The statute does not say that leave can be denied if there's improper use or a pattern of abuse. So why does the law say that you can prohibit a pattern of abuse? Well, there's conflicting provisions there, right? So there's gotta be some meeting in the middle. We're waiting for DLLR to provide guidance there. The safe bet at this point is if an employee has banked leave, you permit them to use that leave. You only deny the leave if those two criteria are met, meaning not proper notice and disruption. And disruption, again, is not going to be a mere inconvenience to the employer or an employer's department. A pattern of abuse is going to take time to develop. Look at that employee's track record on when they're using leave, what is their history up to this point, and what is their history moving forward with using sick and safe leave under this new law. Are they using it on Mondays and Fridays? Are they consistently not providing notice? Are we catching them in lies, seeing them on Facebook doing things when they should be in bed? That sort of thing.
And then my second question is, separate from our PTO policy, our holiday policy dictates that an employee must work the last scheduled day of work and the first scheduled day after the holiday. Does sick and safe kind of kick that to the curb?
With those requirements on your holiday policy, you would not be able to use your holiday leave as leave that complies and counts toward the 40-hour minimum threshold for sick and safe leave unless you got rid of those restrictions.
I think the question is, if you take a sick and safe leave, are you still eligible for that benefit because you didn't work that day after the holiday because you were sick?
Oh, yeah, I would say no. If that employee is, if that policy is, I'm sorry, I misunderstood your question. So if that policy exists separately from your sick and safe leave policy, then you can enforce that policy based on its terms as long as you have your separate sick and safe leave policy. One doesn't impact the other if your holiday policy has nothing to do with the employee's availability to use sick and safe leave. Does that make sense? No.
I actually think you'd be playing with fire. I think what would happen is arguably you'd be interfering with somebody's right to use sick and safe leave because you're penalizing them by denying them a holiday simply because they were sick on the day before and after the holidays. I think a creative plaintiff's lawyer would come back and say, you unlawfully interfered with my client's right to use ESS by dinging them on a holiday. So, I mean, again, we're flying blind here because there's no guidance, but I think it would be a risky move to enforce that.
So this question is an example of where I think reasonable lawyers can come to different conclusions. And
I'm not reasonable, so.
and I'm stepping in it here, but the reason I answered the way I did is because your holiday policy is separate and apart from your sick leave policy. If you're still giving that employee paid leave for that sick leave reason, then you are letting that employee use his or her earned and banked sick leave. So that's why I answered the way, not that Eric's wrong. I mean, you are playing with fire, and a novel plaintiff, a lawyer would probably try to capitalize on that, but I don't think it's legal.
No, it's not. He's not as cynical as I am because he hasn't done it so far.
Question over here.
Just 2 points of clarification. I think I understand it, but just want to clarify. So the call-offs, right? Assuming you've got a call-off policy that allows 7 days throughout the year, right? Before actions are taken. Does this now increase that to 12 days?
So I think Eric and I have come to the same conclusion on this one. Although there are other lawyers who we've talked to have come to different conclusions. And we think it's, if you're going to use the 40-hour, so 5 days, we think it's 5 days of immunity, basically. Right. Yeah, so it would go to 12.
Okay. Not officially, but de facto, it's like they get five free days.
5 free days, okay.
Yeah.
And then the second point, we have an annual payout policy, right? So an employee can cash out 40 hours of their PTO if they maintain a balance of 80 hours. So can we exclude the 40 hours of sick and safe leave? Do you know what I'm saying? So say they've got 40 hours sick and safe leave and 40 hours of PTO time, assuming you break them out, correct? They've got 80 hours of total leave, but can we deny a payout based on the fact that they've only got 40 PTO and 40 sick and safe?
I think
Bet you haven't got that question.
Yeah, I think you can, because now you're in a situation where your payout policy is governing. So Maryland law says that your obligation to pay out any accrued leave or termination is driven solely by what your policy says. So if you wrote your policy to say you got to have 80 hours of PTO exclusive of ESS leave, you could do that. I think that's perfectly legal. Nothing in this law says you have to pay out unused ESS leave. In fact, it specifically says you don't have to pay out unused ESS leave. So yeah, if you write your policy to expressly say that's what you got to have, I think you're all right.
Yeah, question right up front here first. I'll come back to the mic second. Here you go, ma'am.
So if I currently am under a CBA that was prior to 2017, do I have to make any policy changes now?
If you are under a CBA that was entered into before June 1st of 2017,
Yes.
you do not have to modify that until the expiration of that contract. So no renewals, but so if your contract goes from May 1 of 17 to, or June 1 of 17, or May 1 of 17 through somewhere date in 2020, upon that expiration, you're going to have to modify your CBA at that point.
Thanks. So if you already have a front-loaded sick leave policy, say for 3 days, and you want to continue with a front-loaded policy with the new plan, and potentially some people have used a day or two so far in this calendar year, so what happens for the rest of the year? People haven't used some of it, then they get the additional 4, or do you prorate the whole year back somehow?
Logistically, I think what you do there is if you're already offering 3 days, you're going to bump it up 2 days, right? So you got your 5 days.
Yes.
If you have an employee who has already used 2 days as of today, for example, then that employee would have 3 days left. Employees who had not used any of those 3 days now have 5 days.
So my question is kind of twofold. One, for exempt employees, we now are required to track hours worked, correct? And
You
then,
have to track ESS leave.
correct. And then the second question is for exempt, highly commission-based, what are we to pay out for PTO? What hourly rate are we to use?
So what other states have done, and this is what I'm using to inform this answer, is you need to calculate what that employee would be paid for those hours worked. So calculate it down, if you can, from an annualized basis to a monthly to a weekly to the day, and then pay it for that day.
I would probably go, so I've had this question too about, well, do you look at their commissions over the last month or the last 6 months? What if they had a killer last month? And I said, go with a year. A year is probably your safest. Look at their W-2 earnings last year and just average that out. But again, we're guessing. We're just looking at what other states have done and using common sense, which doesn't always work in the law business.
What Massachusetts and California have done is a 6-month look-back window. That doesn't mean Maryland's going to go that route. In fact, Maryland's law is more liberal than California's law, which doesn't always happen. So, who knows? And that's not meant to be a political comment. It's just...
Yeah, it is. At least for me.
I want to go back to eligibility, and you mentioned that somebody has to be employed for 106 days before they become eligible for the leave. And then you used an example that said once they worked 900 hours, then they're eligible. So for us, we have a lot of substitute with school systems. We have a lot of substitute teachers that work as needed. So do we count it on their first date of employment, the 106 days, or the 900 hours was just an example? So 106 days after they're in the system, no matter if they've worked or not, we're giving them.
That's right, it's 106 calendar days, so they could work one day during that 106 calendar days, and then they're running at that 106-day clock. But of course, they aren't going to be working enough to get to the regularly work 12 hours per week in order to be eligible under the Act. The 900 hours was an example on how much, how many hours the employee had worked, so we can say for an accrual basis how many hours of leave the employee would have earned at that point. So the two are separate.
Over here's a question.
Someone has 3 weeks vacation. Can we have 1 week of those be ESS earned and the other 2 vacation, but only with the 1 week for ESS, they can basically come and go as they please? And just change our verbiage in our handbook, because otherwise it could be, then there's an extra week, then you get the paid holidays. I mean, I think everyone.
Yeah, unless you want to build another week onto there for ESS, what you can do is modify that 3 week of vacation policy so that that 40 hours, that 1 week's worth, fully complies with the Healthy Working Families Act, and then you can keep your vacation 2 weeks as is, but you're going to want to document that and explain the difference.
And we should front load that then too, right?
That really depends on what you want to do, how you currently do it, would just really dictate that answer.
So you can change the verbiage in the handbook as long as it complies with this new law.
And actually, the point people seem to be confused on is you can do exactly that, and you can tell the employee, look, you can still use that 40 hours of ESS for vacation if you want to. Nobody's telling you you can't use it for vacation. So you still got your 3 weeks available for vacation if you want it, but the first 40 hours are available to you to use for any of these reasons under the law. So you don't have to give advance notice and all the other stuff. So that's a really important. I've had a number of clients get confused on this. You're not taking anything away from people. They still have the same amount of leave, but 40 hours are carved out for ESS if they want to use it for that.
So if you have just a 40-hour policy and it can be used for any reason whatsoever, but I choose to use it for vacation, that's my choice.
Right.
And you don't have to give me anything above and beyond
exactly.
that.
But we can't tell them when to use the ESS. Like for construction business, bad weather days, if it's going to rain for a week and there's nothing to do, we can't. So that's whenever they want to use it.
That's correct. Right.
Based on whatever.
You got it.
All right, I'm sensitive, we're up against the clock, and the meters start at 9, and they probably aren't real particular about 9:15, but I want to make sure we don't start a Valentine's Day with a parking ticket. So let's give Eric and Garrett a round of applause. And also want to thank Cumberland Valley SHRM. Let's give them a round of applause for partnering with us on this. And thank you for providing some information. I know there's still some more questions. They're going to be around for a few minutes afterwards. You have their contact information. We'll stay close to this issue. We'll post it on our website. We'll share with SHRM so you have up-to-date information. We'll share the podcast. We'll also make sure you get the other presentation. And if you just give me 1 more minute, please. It's not quite 9. Because this could help you, I promise. I know you got to get out of here. This is the importance of advocacy. So when the folks from SHRM and we ask for written and personal testimony to go to Annapolis, it's really important. We had some changes made because we had businesses come to Annapolis and talk to them. So I'm just giving you the heads up, $15 minimum wage is on the horizon. Fair scheduling, you have to give 3 weeks notice, scheduling to your employees is on the horizon. And you're not allowed to ask salary history of potential employees is on the horizon. So when we ask for your testimony and help and advocacy, we'll expect some support there. And if you serve on a nonprofit board, make sure that organization is compliant, because even if they're a small organization, if it's unpaid, they can still get fined. So that's it. Have a good rest of the day, and they'll be around for a few minutes afterwards. Thank you.